Morning, everyone. This is Anae Augustini. I'm CEO of CID Insurance Programs. Welcome to our webinar on E&O. We're trying to go advanced version with called coverage differentiators. We're lucky to have Kevin Wills of USLI, an expert in E&O insurance. And he's going to be our presenter for the day. Dan Mulligan is our professional liability underwriter. He's our senior underwriter, so he will be on board as well. And then, of course, Kaylee Bolger, who's our marketing coordinator, who makes sure that everything goes smoothly. So I'm going to turn it over to Kevin and let him get started.
Hello, everyone, and thanks for attending. I see a lot of names that were on the last webinar we did a couple weeks ago, so thanks for coming back. And hopefully this will be a little bit more advanced than the last time. We'll kind of go through a little bit of the basics again, just to give a refresher. We'll talk about, why do you need E&O? We'll get into a little bit of sample form language. We'll talk about some of the basic coverage differentiators, and then we'll talk about some of the other ones that are more, let's say, advanced. So why do you need E&O? Well, lots of reasons. But really, in this environment, it's more litigious than ever. And everybody is so willing to point the finger at someone else that they made a mistake. It's their fault. You've caused me financial harm. So more than ever, it's so important to have some protection. I mean, a lot of people think that general liability policies cover a lot of errors, and they think it's a catch-all type policy, especially the non-sophisticated buyer. And so often you hear how they're disappointed where a claim wasn't covered because there's a specific professional liability exclusion on a general liability policy. So it's really important to, if someone is providing a professional service, to make sure that they have professional, along with the GL, along with everything else that they need, just to make sure that they're adequately covered. I mean, a lot of times these suits can be frivolous. I mean, people just accuse businesses of making errors, and they want to be paid. And if you don't have insurance to cover that, it really comes down to having someone there, having your back, and really to defend. As we'll go through a little bit later, you're going to see a lot of times the cost to defend is a lot more than actually the indemnity request. It just takes a long time to make sure that to prove innocence in a lot of cases, especially for small businesses where you really just don't have the resource to hire outside lawyers to try and defend you. I mean, we've seen cases where it could actually bankrupt a small business. So really important to have E&O when you're performing a professional service. So this is a standard definition of what professional liability coverage is. I mean, it varies carrier to carrier. One of the things about professional liability versus the GL that a lot of you probably work with on a day-to-day basis is that most of the time it's not an ISO form. It's forms crafted individually by different carriers. So every carrier that's out there most likely has a different form. Most likely everybody piggybacks off of one another. So you're going to see language that maybe another carrier has, but everybody tries to mimic each other, but it's not ISO regulated. So you'll see different definitions for different carriers. So it's important to at least understand what you're looking at when you're looking at a form. So I'm going to read this one to you. This is a basic insuring agreement. The company will pay on behalf of the insured any loss, excess of the deductible, not exceeding the limit of liability to which the coverage applies, that the insured shall become legally obligated to pay because of claims first made against the insured during the policy period or, if applicable, during an extension period for wrongful acts of an insured. So that's a lot of words there, and a lot of those words we're going to talk about, but that's what you're getting when you get professional liability coverage. So what is a loss? So what many policies would define loss in these four things: damages and settlements, any interest, whether it's pre-judgment or post-judgment, punitive or exemplary damages, and that'll depend on the form and the state, and criminal or civil fines or penalties. So then what is a claim? So a claim is a demand for money, and this is important, as compensation for a wrongful act. So most of the time within professional liability, within E&O, it's a monetary demand. It's a monetary loss is what you're covering. Non-monetary claims are typically not covered within E&O coverage grants. Sometimes you're also going to get involved with some coverage for judicial and administrative proceedings, where someone's holding someone responsible for that wrongful act. So there begs the question, what is a wrongful act? So wrongful act is an important definition and something that you need to look at from various carriers, depending on what type of coverage you have, whether it's E&O or a media policy or even cyber policies. You want to look at what is the wrongful act, how is it defined? Most times for E&O only, it is actual or alleged error, so that's important. Error or omission or negligent act of the insured or any person for whom the insured is legally liable in rendering professional services. So the key there is that it has to tie back to professional services. If you are negligent, but you're not performing the professional service that's listed on the declarations page, most likely there's not going to be coverage. If you're a management consultant and you happen to be doing interior design and you make an error in interior design, well, quite honestly, you're probably not going to have coverage on your professional policy that's covering management consulting services.
Okay,
so this professional,
that becomes a really important part for brokers to really have a clear understanding of all the activities that their client is doing and make sure that that's reported on the application.
Without question. I can't tell you how important that is, because a lot of times when cases are adjudicated, they're always going to look at, judges are going to look at what was on the application, because it's most of the times it's a responsibility of the carrier when they have an application to look and see are all things that are listed within the application addressed, whether via on the deck page or are they excluded. So it's important. I mean, we've seen cases where I'll go back to the management consultant where someone would list on the services of doctor. And if an underwriter doesn't go ahead or the agent doesn't go ahead and address doctor on the description of operations, there's a chance that there'll be a real fight if there's a claim resulting from the services as a doctor. So it turns into a med mal policy, which there was never any intent. So the insurance company, I can guarantee, is not going to want to pay a claim for med mal when they were covering management consulting services. But if they don't exclude it, well, maybe there could potentially be coverage, but that's not something you as a broker would ever want to take a chance on. So it's important is to make sure that whatever services are being provided are being covered. Very great point. Thank you. The other key thing is, if you can go back a slide for a second, is services rendered to others for a fee. So that's a real key point in a lot of forms. So, and we'll kind of talk about this a little bit as we move forward, but you want to make sure that if someone's performing services pro bono, they're not getting paid for it. They're doing some grant writing work for a local charity and they're not getting paid, and there happens to be a claim, a carrier could exclude coverage if the form says for a fee. I mean, there are ways around to remove that language, but just be very cognizant if your client does not get paid for the work, because that's an important thing you'll see for a fee. Okay, thanks. So here's another one that we see all the time, and this varies from carrier to carrier. It varies based upon the size of the account and the exposure that's out there. But really, an important thing to look for is whether defense costs are inside or outside the limit. So this is pretty basic, but it's very important as well. So inside the limit, of course, erodes the liability limit. So defense costs will erode the total limit from the policy. Outside the limit does quite the opposite. It means it does not subtract from the liability limit. So if there's a suit and there's a suit for $1 million, and let's say there's suit for $1 million, and you have a $2 million policy, but defense costs equal $3 million. Well, guess what? The defense costs are going to eat up the liability limit, and you're not going to have enough coverage there to pay the the loss. So you just want to make sure that, if at all possible, you get defense outside the limits. The last thing that you want is not to have any coverage for what you anticipated having coverage for because you're paying lawyers. And absolutely, in most professional liability claims, the cost to defend is more than the cost to indemnify. I see it all the time. I can tell you this, it also influences claims people on when to settle a claim. I can't tell how many times where it's debatable whether there actually is the need to indemnify, but when they start looking at the cost of defense, they start to figure out what makes sense for the company. A lot of times they'll settle even when there isn't fault because it's just cheaper to settle because of defense costs. So the point there is that defense costs are expensive. You want to make sure that defense costs are outside the limit, if at all possible. Oops, sorry about that. What defense costs include: lawyer and other legal fees, court costs and fees, the cost of expert witness, investigation costs, bonds, appeals, are all things that defense costs include. The next slide here it talks about two different types of forms. It's the duty to defend versus a reimbursement form. A lot of times, especially on the smaller E&O, it's mostly duty to defend. And that's really good because it automatically provides legal counsel for you in the event that you're named in a suit, or your client, of course, is named in a suit. So you don't have to worry about finding a lawyer, going out, seeing if you need to get approval for that lawyer, then submitting a bill, being reimbursed. You automatically have coverage, and usually that's across the country. So duty to defend is what you see most of the time. But then again, larger E&O, a lot of times they have outside counsel, or they actually have in-house counsel. So what they want is to utilize their own counsel or the counsel that they're familiar with, and then be reimbursed by that. And sometimes, the carrier is going to want to know who you're using so that they can feel confident that they're representing their best interest. But most of the time, again, it's duty to defend. Here's another one. The term you hear is the word tail. And what the heck does tail mean? Really it's a claims-made policy. And if you guys remember the last presentation, we talked claims-made a little bit. And claims-made is a great coverage form. It really allows protection for services that are performed when it's really hard to pinpoint when an actual claim occurred. The problem with claims-made is that once you stop having coverage, or once you stop making payments, or you let the policy lapse, there is no more coverage. So a lot of times you'll have a business that is either bought or sold, or deciding that they no longer want to be in business. So what happens if there's a claim that's reported after the fact? There's no coverage unless there's some tail coverage. So the problem that you have is most professional liability claims are what's called long-tailed. And what that means is it takes a little bit longer to discover these claims. So a lot of times, if you go back to like a tax preparer bookkeeper or an accountant, a lot of times the errors that they make aren't found until 2 or 3 years later during an audit. And all of a sudden now you need to go back and see if there's coverage. As long as the accountant had a policy enforced and still has it enforced, there isn't an issue. But if they had a policy enforced, they decided to let it lapse and they didn't buy any tail coverage, then if they report it, the carrier is going to say no. So really what you're looking for is, you'll see 1, 2, or 3 year ER, it's called extended reporting provisions. I've actually started to see 5 and 6 year extended reporting provisions as of late, and it's usually upwards of 100% of premium. Sometimes you see 200% of premium, depending on how long you pick. It's just important to know, that's all. Consent to settle. So this is a favorite of mine. It's called the hammer clause. So something different about professional liability policies is that they give the policyholder the right to accept any settlement offer that becomes available. What happens is this: A traditional old school professional liability policy has what's called now referenced as a hard hammer, which means once the case can be settled, the insurance carrier will go to the policyholder and say, we can settle this claim for $200,000. We need your permission to do so. And hopefully, the insured says, okay, sounds good, makes sense. There are a lot of times where people just don't want to settle. They don't feel as if they did anything wrong. They don't want someone to gain or get a financial gain out of something that really they never should. And they may hold on and they want to fight. And they want to dig their heels in the ground and they want to continue to fight. Well, with a hard hammer, it means, okay, you can fight, but the most we're going to pay is that, $200,000. Over time, things have softened, and now it has become a percentage. So what you're going to see are different percentages. Common ones are 80-20, 50-50, 75-25. So what that means, I use the 80-20 as the example. So say that same scenario happens and the settlement offer comes through, it's $200,000. The policyholder says, no way, I'm not settling. The insurance carrier says, okay, I guess we'll continue to fight for you. But now, anything that happens moving forward, whether in defense or indemnity, you're on the hook for 20% of that, and we'll cover the 80. And again, it depends on the percentage. If it's 50-50, then it's 50% we'll cover, and 50% the policyholder's covering. So look for that in policy forms. Hammer clauses are not invoked all that often, but it definitely is an important thing because it does keep control of the claims with the insurance company. Every once in a while, I'll see a request for removing the hammer clause, which is something that usually we're unwilling to do. And I think most carriers are, no matter how soft the market may be, are a little skeptical to do. Claims made versus occurrence. I only bring this up. I know we talked claims made last time, and I don't want to go into it too much. But I want you to be aware that there are professional policies out there that are occurrence-based. So let's talk claims made real quick. So you'll see two different types of claims made. You'll see claims made and then claims made and reported. Really, the basic difference is that claims made and reported, you have to report the claim within a specific time period. A lot of times you'll see as soon as practicable. A lot of times you'll see people that a policy period's coming to an end, and what they'll do just to make sure that there's potential for coverage, they will send in potential claims, maybe 5, 10 things that they think could possibly be claims, even though there's been no allegation, just to make sure that they was reported within the policy period. That's called laundry listing. Occurrence-based, what you see, that's really popular in, I'd say, the media space. So there's a huge blend in E&O lately, whether it's tech E&O or miscellaneous E&O and media, it's all coupling together. And a lot of times media, which can be broadcasters, publishers, radio stations, things like that, they're typically written like a true media policy is an occurrence-based policy. And the reason that is because it's very easy to pinpoint when you slandered someone because it would happen on a specific date or a specific time, or it's very easy to pinpoint, where on claims made policies, it's typically not as easy. Retroactive date, this is, again, a basic thing, but I mention it here only because it's very important when you're looking at, two proposals from two different carriers. You want to make sure that you're getting for your client the best retroactive date. The best retroactive date is full prior acts, and full prior acts simply means that there's coverage from the time your business started, where a lot of times carriers are reluctant to give full prior acts. They're willing to give you coverage from inception, and what inception means is the inception of the policy. One thing that also is important is you want to make sure that if you do have a current policy in place and you're considering moving it to another carrier, make sure you get that retro date matched. You don't want there to be a gap in coverage because you move carriers. That's the wrong thing to do. So make sure they match the retro dates. It's very, very important. Sorry about that. Independent contractor coverage. This is one that I get a ton of questions on. I'm sure Dan does as well. Are independent contractors covered? What's that? You get a ton of them, right, Dan?
All the time.
All the time. So what does that mean? So what it means to me, and you can tell me if I'm wrong here, they want to know, one, are they covered for the acts of the independent contractors that they hire? And in most cases, the answer is yes. You're going to be covered for the acts of the independent contractors that are working on behalf of your organization. But the other part of that question is, are the independent contractors themselves covered on the policy form? And that is going to differ from carrier to carrier. So you want to take a look at that. One other thing you need to make sure you do is the policy form may specifically cover independent contractors and their services. So, they're covered on the policy, but you want to make sure that if they're doing something different outside of, I'm sorry, I'm rolling the mouse here too quickly. If they're doing outside of what is on the declaration for description of operations, you want to make sure that if you want specific coverage for that independent contractor, that what they do is listed as well. For example, so say you're writing a printer and that printer hires a graphic designer. And suddenly there's a claim related to the graphic design. Maybe it's an intellectual property type claim, and it all results back to the graphic designer being negligent in utilizing a specific image. So, of course, the claim would come through. The printer gets sued. Maybe the graphic designer gets sued. You want to make sure that graphic design was also listed on your declaration, because if not, there's potential for there not to be coverage because this wasn't an error in printing. It was an error in graphic design. So just important that you do that. Punitive damages, you don't see this a ton. This is more of a D&O and EPLI type issue, but what you want to be careful of is if it's available in a state, hopefully your form that you're writing has this coverage. Again, it depends on whether it's insurable or by law or not. Just make sure that if it's available, you get that coverage. And really what it covers is an egregious claim. So some states say, hey, we're not going to let you buy insurance to cover something that you did was so terrible that we want to allocate punitive damages upon you. Some states say, yeah, that's okay to do. Personal injury. This is another one where we get a lot of questions. And really what personal injury is typically it's libel, slander, those type things. But there are other things within personal injury that people tend not to know. Wrongful entry or eviction. So even if that is the wrongful eviction of property, so say you're a property preservationist and you're removing property from a bank-owned foreclosed home because the former owners didn't remove this stuff after they were foreclosed, and you evict that property. If there's any type of issues with the property being damaged, typically the coverage could come into personal injury, which quite honestly, I don't think I would have known if I didn't know how to read a professional liability form. It just doesn't sound like that's where coverage would be found, but that is where coverage is found. The thing that's important is that that's while providing professional services. So it's not the same as personal and advertising injury on the GL form. The question is asked all the time. So really the difference is personal injury while performing a professional service. I'm an advertising agency, and while within my services, I go ahead and use I have some type of intellectual property type of claim, or I have some type of personal injury claim where I slander another business. Coverage will be found here within personal injury. If you were actually advertising for yourself and then you're sued, that's where the GL form could respond. So really important differentiator there. Make sure that anybody who's, you should make sure that you have coverage for personal injury within your E&O. And this is an example. I'll just read it real quick. Bonnie and Lance decide to hire Morgan to capture images of their newborn son. They meet with photographers at Morgan Image and sign a contract. They are thrilled with the results and receive the proof book. When they receive the proof book, 3 months later, Bonnie's friend is viewing Morgan Image's website and sees the photo of Bonnie's son as part of sample images and calls Bonnie to let her know. Bonnie is irate when she an image, and she thought it was a private image, and this moment is now displayed on the website. She learns that the contract she signed states that images can be used for promotional purposes without her consent. Despite this fact, she sues Morgan Images. Although they won the case, defense costs were $78,000. So you're like, what the heck? They signed a contract, said they could use the images, they used the images, and yet they still sued? Yeah, they did, and wound up paying $78,000 just in defense because we had to defend because there was a invasion of privacy allegation. This is just a perfect example of how small little things can result in large defense costs. Intellectual property, this is another one, especially in that media space. You want to make sure there's protection anytime that you're involved with advertising a product. So intellectual property, here's the definition you'll see in a lot of forms, means a claim alleging infringement of a registered copyright, title, slogan, logo, trademark, trade name, service mark, or trade dress in the performance of professional services. Here's an IP claim. See these all the time. You see this a lot in the tech world as well. Jane Smith had been programming for a large IT firm for 5 years, designing enterprise management systems. Due to a decrease in orders, the software company must cut expenses and went through a wave of layoffs, which included Jane. Jane Smith decided to start her own business that will specialize in ERP. Since this is where her expertise lies, she develops a new packaged software product that provides enterprise management for small businesses. Custom Developer Inc., her old company, feels that software code was used in her new software and then files suit. Very common claim you'll see for infringement. Happens all the time. So you just want to make sure that anybody who's performing professional services has intellectual property coverage as well. This is another one. This is something that is not in all forms. So you want to take a quick look and make sure that if there is this exposure, that there is coverage. Bodily injury and property damage arising out of professional services. You'll hear this referred to as contingent BIPD. And really where it's important is anybody who's involved in any type of design or medical classifications. Perfect example is like an interior designer. So say you're involved with designing a specific space and you didn't install the space, you just went ahead and designed it. And once it's been installed, someone actually gets hurt as a result of your design. There's actually potential for bodily injury. Now, as you guys probably remember from the last presentation, bodily injury and property damage are not covered in a traditional professional liability policy. But if you have this extension, if that bodily injury can be pinpointed to your professional service, this is where this coverage is very important. And you can see that in medical as well. So anybody who's caring for someone else, you want to make sure there's contingent BI within a policy, like a home health aid. You want to make sure that if somehow they injure someone while caregiving, you want to make sure that this coverage is actually in the form. Because, again, most policy forms, it's not in there. So you just want to make sure it's there. Here's a couple other things real quick you want to take a look at. We see a lot of things. E&O is really a contractually driven product, and a lot of the policies that we sell are as a result of a contract requirement. And lawyers are more and more creative. They continue to push. So we continue to see more and more requests for these coverages here. Additional insured, we're actually seeing blanket additional insured quite frequently. They just want to make sure that if they're named in a suit based upon the performance of professional services of our insured, that their client is covered. So you want to make sure that if the contract states that they need to be listed as an additional insured, that your carrier is willing to do that. These next couple carriers are maybe a little more reticent to offer. Waiver of subrogation. I mean, these are very familiar to anybody who underwrites GL or sells GL, but professional, this is relatively new. So waiver of subrogation basically waives the right for the insurance company to collect any reimbursement from any other party. So basically, you're unable to sue once the policy paid out. So that and primary and non-contributory are two things that you're going to see. They usually are in concert together, and carriers are very reluctant to offer primary non-contributory language especially when you're one component of a large project. The last thing that a carrier wants is to now be the primary insurer on a large project when you were really only covering, the little interior designer. And then cross liability is something that you don't see a ton of, but it's really a GL endorsement. But you'll see that every once in a while, and it basically removes insured versus insured type exclusions. We kind of talked about this, so I don't need to dwell on it. Pro bono. So if they are performing services that they're not charging a fee for, make sure that there's a pro bono extension within the policy form, or they remove the for fee language on the deck. Reputation restoration expense, you'll see this. Some lawyers' policies have this, accountants, and basically what this is reimbursement for public relations costs to help combat bad publicity. So usually it's done via sublimit, and it just helps the hiring of a PR firm. This is one that I'm seeing a lot more requests for: subpoena, supplemental payments, disciplinary actions coverage. So really what this is an extension for, sometimes it's $5,000, $10,000 of coverage, and just helps pay for attorney fees, coverage for lost wages to attend a trial, coverage to defend any type of disciplinary actions by licensing boards, things like that. So you kind of want to see if it relates. If you're in a profession where there's potential for disciplinary action suits, you want to make sure that there's coverage within the form. We're starting to see identity theft expense being requested sometimes within E&O. A lot of times there's a lot of cyber extensions that are being added to E&O at this time. Identity theft expense is one of those. Dan, you could probably talk more about this, but coverage for owned properties. I mean, you see this. Dan is a property manager, E&O specialist, knows more than I ever could. And this is a coverage that is important for a property manager. Right, Dan?
Right. What that basically is doing is your standard E&O policy is going to exclude coverage for a property that you own. So if you're a property manager who happens to own some of the properties that you manage, you get this endorsement on the policy that will protect you from any claims on properties that you own.
Exactly. So it's important if property managers, a definite case there. If that's something that you're writing, look for that type of coverage. Kidnap expense is another one, kind of with identity theft that people throw in, but it's another coverage you see every once in a while. Sometimes people ask for technology products coverage to make sure that the actual product that is created, manufactured, developed by the named insured is protected. So something that you want to look at if your insured is involved with developing software or some even hardware product. We talked about this briefly, but the description of operations is so important within E&O. There's a fine line between being too descriptive and not descriptive enough. So I think it's better to be broad. I'll go back to my traditional management consultant type of situation. It's better to be described as a management consultant versus a management consultant that specializes in healthcare reform costs for hospitals on the East Coast. All of a sudden, that definition is really narrowed by you adding all those descriptors, and say somehow they got involved in consulting about technology, there wouldn't be any coverage because that description is so narrow. So a lot of carriers are willing to kind of carve out or craft descriptions of operations any way you want. But so you really want to make sure that you hit on the major services, but don't be too descriptive at the same time. Included but not limited to language. This is something you see in the tech world. That basically gives you a broad brush that it's not limited to technology service. It's not limited to what's described, but it's something within that realm. So that makes something much broader when you see the term included but not limited to. So that's favorable, especially in tech. these are other things we're seeing, and there's all kinds of information, cyber, whether it's privacy breach liability or privacy breach expense. We won't go down that path today, but that's something that we're starting to see blend into E&O policies. So a lot of times carriers will offer extensions for cyber liability within E&O, and contracts will ask for that. So make sure that the contract asks for that, you see if it's available. One thing I want to mention, if you guys have any questions throughout this, I know I've been going on for a while here, but please feel free to chime in, ask via the chat. I'd be more than happy to stop and answer. I'm sure if you're thinking about a question, probably 3 other people are thinking about the same thing. So feel free to go ahead and ask a question periodically. But while we're waiting for questions, I will go into, here's a quick network security and privacy example. I mean, this is something you see all the time. We see underwriters do the same thing. Management consultant loses a laptop while working on a project for a client. The laptop holds data on the client's customers, including email addresses and bank account information. Pretty basic and common network security and privacy example. And I'm sure you can see that one happening. Oops, sorry about that, guys. In the cyber world, and again, this is not a cyber webinar, but cyber coverage differs so much from carrier to carrier. I can't even get into how different each carrier's definitions are. So be careful when there is a cyber requirement in a contract that it does address both first and third party exposures. Okay, just be really cognizant of that. Question to ask, is the entity collecting, storing, or transmitting personally identifiable information directly from the customer? If the answer is yes, the entity has a first party exposure. Entities with first-party exposures almost always have third-party exposures. So, but most of the time, your consultants traditionally only have the third-party exposure. So the network security and privacy liability is enough to satisfy the cyber requirement. Real quick, I just want to go into the legal foundation for a claim and kind of get into a claim scenario. Here's what's important. There has to be a professional duty. That professional is held to a higher standard of care. There is a breach of that duty or a failure to conform to the standards of that duty. A causal connection between the conduct and the resulting injury, and was there financial damage that occurred as a result of the error? There's a case here. Bear with me one sec here. Okay, I'll go through this one pretty quickly. I know we're running close on time. A management consultant specializing in distribution efficiency is hired to reduce the cost of distribution for a large chain of retail baked goods stores. He advises the company to concentrate on baking and packaging, selling the trucking unit. They contract with a trucking company that specializes in food distribution, and they cut distribution to a 500-mile radius for each store. This management consultant works closely with the company to complete the changes by June 30th, which is the end of their fiscal year. Trucking companies demand more money for the services than first anticipated because of the rising price of gasoline, and extend negotiations to delay the distribution of the company's flagship product, Independence Day themed cupcakes. The themed cupcakes do not arrive in time for the holiday, and a rival similar product capitalizes on the lack of the company's flagship product and dominates the market in the region. The management consultant is sued for negligence and $250,000 of damage. So here's the questions. Did a professional duty exist? Well, yeah. They were hired to consult on how to reduce the cost of distribution. So yes, there's definitely a professional duty. Did they breach that duty? Yeah, because the plan that they put in place was terrible, and really, instead of helping them increase their business, it actually decreased their business. So absolutely. Was there a connection between the conduct and the resulting injury? Yeah. The decision to change the trucking system caused the product not to go out to the market on time. And here's the key, as I said, financial damage. Yeah, there was financial damage. They lost out on selling product and also may lose future revenue, and that's where that $250,000 suit came from. So you see all 4 elements of the claim is involved there, and that's just a typical claim scenario you'll see within professional liability. All right. So
Kevin, we have a couple questions. I don't know if they're appropriate.
Oh, good.
But the
Yeah,
question
please.
goes back to the hammer clause. Does a hammer
Yeah.
clause have a different name on the policy?
Within the policy itself, you'll see it'll say consent to settle within there. You'll never see the words hammer clause in a policy. So look for consent to settle, and then you'll typically see the percentages if it is a softened hammer. All right, here I do see it. Thank you for all the questions. I appreciate this. Yeah, I see some more here.
One more, yes.
Okay. Yeah, go ahead.
Can contingent BI PD be excluded from a GL policy?
Can it be excluded? Yeah. So bodily injury and property damage resulting from professional services is almost always excluded from a GL policy. So that's why it's so important that if you have a GL policy and you have a professional policy, and that professional policy, that excludes bodily injury and property damage. So where do you get coverage for bodily injury and property damage resulting from professional services? Only if you have this extension, that contingent BIPD. So absolutely, it can be excluded from a GL policy. Most times it is.
And then the last, we have another, do you pay for tail coverage now or when the policy is canceled?
Typically, carriers are pretty strict about this, and they usually want payment within 60 days. You need to make a decision within 60 days. But the last thing you want is, a year later, I think I might have a claim. Let me go back to the carrier and say, I want to buy tail coverage on my policy that was from 2015. Well, the carrier's not going to do that. So, yeah, you definitely pay for it. Again, it's usually a percentage. It depends on how long. Different carriers have different percentages. I mean, 1 year I've seen 65% of premium, 2 years, 100% of premium, 3 years, 120. This depends on the different carriers and the different products and exposures. But yeah, that decision needs to be made pretty much when the policy is canceled. Great questions, guys. Thanks. Keep them coming if you have them. But while we're waiting, let's just go through real quick just to make sure that we're all on the same page as it relates to what's important. So when you're looking at you have two carriers' terms in front of you, what are you looking at? You're looking at the retroactive date, the retentions. Sometimes prices are cheaper, but that's because the retention is a lot higher. The big one, I talked about defense inside versus outside. I think this is a very valuable differentiator, and I think that it's worth the extra cost to have defense outside. But that's, again, a decision that both you as an agent and the insured can make. Coverage territory, you want to look at where they're performing their services. If they're performing services within the U.S., it's probably okay to have that limited worldwide territory, which a lot of forms have. But if you're performing services all around the world and you're worried about someone bringing claims outside of the U.S. and its territories, consider paying for that true worldwide coverage. Gets into included or excluded common coverages within here. Personal injury, intellectual property, we talked about those. Some forms contain sublimits for discrimination, although a lot of times that's an EPL type coverage, but sometimes discrimination can be covered within E&O. You'll see that for property managers. You'll see that for maybe photographers, things like that. There's sublimits for that. You want to look for that network security and privacy liability. Sometimes forms will not cover that. If you can get coverage for that, I would advise to do so. And what you need to be focused on more on is what is being excluded. Common exclusions. And some of these are common. Criminal acts, most policy forms are going to exclude any criminal or fraudulent act. A lot of forms exclude fee disputes as themselves, just suing you because you didn't pay. Well, there isn't going to be coverage for that. But you want to take a look at how that fee exclusion is worded and to make sure that if there is negligence alleged, even if it relates to a suit for fees, that there is coverage for that. Again, we kind of talked about bodily injury and property damage. How's that handled? Is contingent BIPD included? Intellectual property. Insured versus insured. This is a common one that we see within billing services. People will set up separate LLCs to do the billing for their healthcare operations. Well, if you're performing services for yourself, that really is a conflict of interest, and a lot of forms will have exclusions related to insured versus insured. You see this failure to maintain insurance. That's a common one within certain classes. So be aware of that. Prior and pending litigation, prior knowledge. So that's an important one, and one where you see some denial of claims, where it's very apparent that there was knowledge of a claim, and within the application they may select no, they didn't know about anything. And then when the claim comes in, it's obvious that there was a demand letter written 3 months before they decided to apply for insurance. Well, the carrier is going to deny the claim, and quite honestly, they may look to rescind. So that's a really important thing and a really important spot to pay attention to when filling out applications. Other things, most policies are going to exclude, EPLI. You may have again, discrimination, carve back, fiduciary, pollution. Those are common exclusions on professional policies.
Hey, Kevin, we actually have another question.
Oh, good.
Okay.
Go ahead. I don't see it.
Oh, no worries. I'm gonna talk to you. Does replacing an E&O policy with another E&O policy with an equivalent retroactive date or full prior acts clause replace the need for tail coverage?
Yes. Yes. So the tail coverage really comes into play when there is no longer any coverage or that entity does not exist any longer.
Okay, and does this amount to the same thing in all situations?
Does this amount to the same thing in all situations? As long as the coverage form is the same, you're getting the same coverage. I would say yes. But again, it really relates to you're coming from one coverage form to another, making sure that the new form is at least equivalent, if not more broad than the other. And again, look for those things we just talked about, defense inside the limits, etc., to make sure you have the same coverages. Then, yeah, as long as that retro date is the same, you should be okay.
Perfect. Thank you.
Okay. So that is the end. Does anyone have any other questions?
Go ahead and type them in if you have any questions that you'd like Kevin to answer for you. But in the meantime, this particular webinar will be published on our website under our resources section under webinars. And so there you could go watch any of there's probably 8 or so webinars that we have published. And you can watch it as if you can go back and watch it as many times as you want. It's a recording of it, so it's just as you're seeing it today. You listen to Kevin talking, and so that's a really great tool. And you can also go there to see our upcoming webinars because we're doing at least one a month through December. Dan, you want to say anything about how that you would like brokers to contact you or work with you?
Yeah, we have applications on our website at CIDinsurance.com, but a lot of times if you have any questions, feel free to give me a call on a lot of the basic risks. I can gather some basic information and call on the carrier and have a quote for you within a few hours there. So if you ever have any questions, I'm always answer my phone, so just give me a call, or you can go to our website and get applications.
Okay, great. There's going to be, Kaylee, any other logistics that you'd like to cover?
No, I think that's all.
Yes, there'll be a survey. We'll be sending some information to you as a follow-up to this and with directions as to where to go on our website to see the webinars. Thank you for joining us. Have a good day.
Thanks, everyone. It was a pleasure.